So this is my ruling on the oral application. The court has heard and considered the petitioner's application for status quo or stay or interim relief that would maintain the petitioner as the governor of Meru County and stop the consequent actions that the judgment of this court has allowed to take place from being implemented. Learned counsel for the petitioner has argued that the temporary relief in whatever form would allow the petitioner to adequately canvass the pending Meru High Court matter, which in the judgment of this court, a number of issues have been reserved for hearing and determination by that court. Further, Counsel Mutuma submitted that doing so would also allow the petitioner to effectively apply for and exercise her right to appeal to the court above. Counsel Mutuma argues that no party would suffer any prejudice, as in essence, the oral application, if granted, would merely maintain and extend the status quo that has obtained from 21st August 2024 for a few more weeks and months. Learned counsel underscored that, on the contrary, not allowing the oral application would result in significant changes in the governance of the county of Meru and would render the Meru High Court matter or any forthcoming appeal academic. In support, learned counsel for the first interested party, Counsel Lawi, on behalf of all the interested parties supporting the amended petition, echoed the submissions of petitioner's counsel and reinforced the need for a status quo order to allow for a seamless appeal process as well as a seamless hearing and determination of the other matter. Counsel Thanji, learned counsel for the respondent, opposed the oral application. She observed that the court is now functus official and the petitioner has other avenues in a matter that is still pending, being the Meru High Court matter, or upon appeal. She concluded by noting that the judgment was clear that the Senate's actions and resolution were constitutional, and thus it would not be proper to suspend that action, and also this own court's judgment delivered earlier in today's session. Counsel Kirimi, learned counsel for the third interested party, and on behalf of all counsel for the interested parties opposed, added and argued that this court cannot stay a negative finding, and the granting of the oral application would amount to this court sitting on appeal of its own decision. Counsel Kirimi argued that stay or interim relief would greatly prejudice the people of Meru, one of which he represents in these proceedings, who have been eagerly awaiting the conclusion of this matter. The grant of the orders sought orally would also prolong the uncertainty in Meru County. He rested by arguing that in any case, it is a weighty application that should be in writing, with all parties being granted time to respond before a decision. I have considered the submissions by learned counsel and reflected on the matter in light of the unique circumstances of the case and the applicable judicial precedent, and I find that this court is not the appropriate forum for consideration of the grant of stay or the grounds adduced by learned counsel for the petitioner. Counsel explicitly referenced other fora that are, to my mind, better placed to consider and apply the injunctive relief sought on the basis of cases filed and pending before them or to be filed before them. I'm also satisfied that the Constitution and statute law provide for subsequent processes that would address any governance challenges that would arise from the operationalization of this judgment delivered a few moments ago. Lastly, I find that neither the petitioner nor the interested parties in support have identified any weighty issue that would or could be a potential error in my judgment just delivered that could form the basis of this court considering if there would be an arguable appeal or a just reason to stay this judgment in the interim. Overall, and noting that Our constitutional order gives the petitioner ample time to seek injunctive relief in other fora, and noting that this has been a prolonged litigation in which the petitioner has enjoyed interim relief since 21st August 2024 with respect to a resolution of the Senate that has been found to be lawful by this court, I decline to grant the interim relief or stay sought orally. Certified copy of judgment and proceedings to be availed on priority. 14th March 2025. So I will work on the slight. Yes, Ms. Tanch, sorry. No.
Thank you, my lord.
Yes.
We appreciate the industry and the time taken to represent.
Councillor Mutuma?
Yes, sir. Thank you, Your Lordship, again for the industry. For your time and ruling. We abide by this.
Thank you, Council. I will. The only minor errors. Sometimes when you read in your mind, you don't catch these errors. You can only catch them when you read out loud. They're very minor, so you'll have this very shortly. Also, there will be a press release that will be communicated. I don't know why my court assistant has looked at me. My court assistant will get the press release, and it will be communicated through the appropriate judicial channels to the media. Before I rise, I'd like to sincerely thank Council on all sides for the manner in which you have argued your respective positions. I have been greatly impressed by the depth of your submissions. And even as a judge, I can safely say that I have learned things from reading your submissions and the manner in which you argued your respective cases. I look forward to seeing you all in future matters. Thank you. Have a good day.